Welcome to International Trade Minute Quickfire Trade News, the essential podcast for today's trade professionals, presented to you by Rydell Law Firm. If you're a seasoned practitioner, this is where you'll find your weekly distilled briefing on the pulse of international commerce and regulation. We bring you the latest legal and trade news distilled into straightforward, bite-sized updates for busy trade professionals. Sponsored by Rydell Law Firm. This podcast is crafted by expert trade attorneys to keep you ahead of the curve with concise, actionable insights. Perfect for your morning commute or coffee break. Stay informed without the fluff. Subscribe now on Apple Podcasts and Spotify and join our professional community on LinkedIn. In today's episode, we unpack major changes introduced by the Trump administration in its first days. Highlights include executive orders targeting trade policy, potential global tariffs, and a review of China trade relations. We'll also discuss updates on export controls, a challenge to the UFLPA entity list, and insights from former Senator Pat Toomey on the administration's trade agenda. Let's get started with our detailed analysis of these crucial developments. In a sweeping first-day directive, President Trump has ordered comprehensive reviews of multiple trade policies, setting an ambitious April 1st deadline for recommendations from key trade agencies. The memorandum targets several critical areas that could fundamentally reshape U.S. trade policy in the coming months. At the forefront is an investigation into persistent U.S. trade deficits in goods, with agencies directed to consider implementing a global supplemental tariff as a potential remedy. The directive also calls for identifying unfair trade practices, including situations where other countries restrict U.S. imports while freely exporting similar goods to our market. A significant focus has been placed on the de minimis threshold, with agencies tasked to evaluate modifications that could better protect revenue and public health, particularly regarding contraband drugs and counterfeit products. The administration is also reopening scrutiny of last year's Section 301 review, specifically examining industrial supply chains and third country circumvention issues. The China-focused elements of the directive are particularly extensive. Agencies must investigate additional Chinese practices beyond those covered by existing Section 301 actions, evaluate China's compliance with the Phase 1 agreement, and consider appropriate responses, including new tariffs. The memorandum also calls for a review of China's permanent normal trading relations status. On the Section 232 front, the administration has ordered a comprehensive review of country exemptions, tariff rate quotas, and exclusions for steel and aluminum actions. Agencies must also assess whether new Section 232 investigations are warranted to protect other sectors of the U.S. industrial base. This aggressive timeline, requiring recommendations by April 1st, is particularly notable given that key positions, including the Commerce Secretary, U.S. Trade Representative, Homeland Security Secretary, and Treasury Secretary, are still awaiting confirmation. The directive signals a clear intent to rapidly reshape U.S. trade policy, with potentially significant implications for trade practitioners and their clients. Moving on to another significant development, President Trump has ordered a thorough examination of the U.S. export control system, with particular attention to potential loopholes that could benefit strategic rivals. The Commerce and State Departments have been tasked with identifying and eliminating vulnerabilities in current export controls, especially those that might enable the transfer of strategic goods, software, services, and technology to adversarial nations or their proxies. The directive specifically calls for improvements to enforcement mechanisms that could incentivize foreign compliance, including new trade and national security measures. This review could significantly impact how U.S. companies engage in technology transfers and international sales of sensitive items. Equally noteworthy is the administration's focus on outbound investment restrictions. The Treasury Department has been directed to evaluate the Biden administration's regulations on investments in China, particularly in sensitive sectors like semiconductors, artificial intelligence, and quantum computing. The review will determine whether these controls should be modified, rescinded, or replaced with more stringent measures. This scrutiny of outbound investment comes at a critical time. As analysts suggest, Trump may expand restrictions beyond the current scope to capture additional Chinese technology sectors. The administration appears particularly concerned about whether existing controls sufficiently address national security threats. These reviews, also due by April 1st, could reshape how U.S. businesses operate in global technology markets and invest in emerging technologies abroad. Trade practitioners should closely monitor these developments as they may require significant adjustments to compliance programs and investment strategies. Up next, in a significant development for trade compliance practitioners, Chinese battery manufacturer Camel Group has mounted a legal challenge at the Court of International Trade, contesting its placement on the Uyghur Forced Labor Prevention Act entity list. The case highlights critical issues surrounding due process and evidence standards in UFLPA enforcement. At the heart of the dispute is Camel Group's assertion that the Forced Labor Enforcement Task Force failed to provide transparent procedures or access to evidence used against the company. Despite having successfully cleared 82 prior CBP detention notices with clear and convincing evidence that their products weren't made using forced labor, the company found itself added to the entity list in August 2023. The case raises particular concerns about the task force's reliance on Sheffield Hallam University reports as potential primary evidence, especially given the appointment of one of the report's co-authors as a policy advisor to the FLETF chair. Camel Group maintains that allegations about their participation in labor transfer programs were based on incorrect interpretations of public documents and photographs. What's particularly notable for practitioners is the emerging tension between CBP's established detention resolution processes and FLETF's listing procedures. The case could set important precedents for how companies can challenge UFLPA listings and what standards of evidence the government must meet to maintain such designations. Trade professionals should watch this case closely, as its outcome could significantly impact future UFLPA enforcement practices and establish clearer parameters for both government evidence requirements and corporate due process rights. Now, we dive into our next news. San Francisco-based Fitbit has agreed to pay a $12.25 million civil penalty to the Consumer Product Safety Commission, following delays in reporting a significant smartwatch defect. Between 2017 and 2021, Fitbit imported and distributed approximately 1.02 million Ionic smartwatches. From 2018 to 2020, numerous users reported overheating issues, with some suffering second and third degree burns on their arms and wrists. In early 2020, Fitbit released a firmware update to address the problem, yet burn incidents persisted. A formal recall was issued in March 2022. However, Fitbit failed to promptly notify the CPSC about the defect prior to the recall, violating regulatory requirements and leading to the substantial fine. This case underscores the critical importance of timely communication with regulatory bodies to ensure consumer safety and maintain market trust. Shifting our focus to potential trade policy changes, former Senator Pat Toomey has issued a stark warning about the scope of upcoming tariff actions. Speaking at a recent Council on Foreign Relations event, Toomey emphasized that many are significantly underestimating President Trump's commitment to implementing broad, aggressive tariffs in his second term. Drawing from his experience during the first Trump administration, Toomey stressed that these aren't mere negotiating tactics. The former senator highlighted Trump's fundamental belief that trade deficits essentially represent theft by trading partners, suggesting this perspective will drive policy decisions more aggressively than in his first term, particularly without the moderating influence of previous advisors. This analysis gains additional weight when considered alongside comments from Dennis Shea, a former deputy USTR. While Shea defended the administration's focus on trade deficits as addressing unsustainable economic patterns, concerns are mounting about potential retaliatory measures from trading partners and their impact on U.S. manufacturers. Of particular immediacy is the February 1st deadline regarding potential 25% tariffs on Mexican and Canadian imports. Former USTR Chief of Staff Heather Hurlburt suggests that if implemented, these tariffs would likely face rapid modification due to market pressures, particularly in the automotive and energy sectors. For trade practitioners, perhaps most concerning is Toomey's warning about the potential for crony capitalism in tariff exclusion processes. The anticipated expansion of national security justifications for trade restrictions, combined with potential political influence in exclusion decisions, suggests practitioners should prepare for a more complex and potentially less predictable trade environment. The broader implications for international trade architecture are equally concerning, with experts expressing significant pessimism about the WTO's future, particularly as more countries adopt expansive national security justifications for trade restrictions. That brings us to the end of today's International Trade Minute. Looking at the critical developments we've covered, trade practitioners should be particularly alert to the sweeping review of trade policies ordered by the Trump administration, with multiple agency recommendations due by April 1st. The potential for broad tariff implementation and changes to export controls could significantly impact international trade operations in the coming months. Keep a close eye on the February 1st deadline regarding Mexican and Canadian tariffs, and consider preparing contingency plans for potential supply chain disruptions. The Camel Group UFLPA case also bears watching, as it may set important precedents for entity list challenges. Thanks for tuning in to International Trade Minute. We hope you found today's episode insightful and useful for your practice. Remember, our podcast is brought to you by Rydell Law Firm, your trusted partner in navigating international trade law. Don't miss our next episode. Subscribe now on Apple Podcasts and Spotify. Stay connected and continue the conversation with us on LinkedIn. Until next time, stay informed and stay ahead.